Hi, everybody. It's Brian Seidensticker again. We had the pleasure of getting Bob Kaiser back with us. There's been some fairly significant news on in the bankruptcy front, at least in New Jersey, and I appreciate Bob joining us to kind of give us an update there. So welcome back, Bob.
Thanks, Brian. I appreciate the opportunity.
Give us I guess give us an update of or what has happened over the last couple months and where we headed here.
Well, when I first met with you when we recorded this, one of the things that I had mentioned, and also that was in the white paper that I prepared, had to do with actions in bankruptcy to recover properties that had already been the subject of final judgments, meaning the plaintiff, in those cases, my clients, had title. And then afterward, the former owner would file a bankruptcy, most often a Chapter 13. I've seen a couple of Chapter 11s that did this, but they're mostly Chapter 13s. And then they would file a lawsuit in the bankruptcy court alleging that the transfer of the property, meaning the taking of the property by the tax lien holder, was either a voidable preference or a fraudulent transfer. Those are two, I would say, terms of art in the bankruptcy. I didn't get involved in code sections in my prior talk with you, and I won't here except to say those are sections 547 and 548. And they are specific to the bankruptcy, meaning they're not rights that you have in state court. You have to file a bankruptcy, and then you sue and you say, essentially, I lost this house and it was worth a lot more than I owed on it, on the taxes. And so therefore, I need to get this back. The law is I'm recovering it for the benefit of my creditors, meaning you got all my money, my creditors don't. Now, as a practical matter, what it meant was the debtor wanted his house back. Now, I mentioned this. In fact, I went into it in some depth the first time we spoke, and I also talked about what the defenses were to those claims. Well, since we recorded this, or right around the time when we first recorded it, there was a decision coming out. And that decision has now been published. And then thereafter, in February of this year, a second decision came out. And the significance of those decisions were these actions need to be brought within a specific time frame in order to be heard, as is the case with every cause of action. I guess we think of them as statutes of limitations. It's not exactly like that. A preference action has to be brought within 90 days of the transfer of the property. A fraudulent conveyance action has to be brought within 2 years of the transfer of the property. Now, there are more elements than that. You just can't say, I lost it within 90 days. You have to prove other things too. Mm-hmm. And we had always presumed, and I think it wasn't irrational to presume, that the transfer of the property meant the date of the entry of the final judgment. That's when the debtor lost the property. My client took title because we got final judgment entered. And then toward the end of December of last year, in a case which has been published, a judge said the date of the transfer is the date of the filing of the lis pendens. And there's a lot of analysis in this. It wasn't outrageous. It was just something that hadn't been considered before. And the significance of that, if you consider the date of the transfer to be the date of the filing of the lis pendens and not the date of the final judgment, that moves the date where you start counting the 90 days back by 6 months, 9 months, a year. I mean, for as long as it took you, you file your lis pendens on the day you file your complaint. Mm-hmm. So that moves the starting date for counting the time back a long way. And if you think about the practicality, and I'm just right now talking about the voidable preference, which is the 90-day test. In my experience, there are almost no foreclosures that can be finished in 90 days from the date that you file your complaint. What that means to me, and I haven't seen this played out yet. There's always a danger in predicting how new cases will work. Mm-hmm. But what that means to me is there can't really be a voidable preference action brought to get a property back, because none of these bankruptcies will be filed before 90 days after you lost the property, because you then count back. If I file my lis pendens on June 1st, I get my judgment on December 30th, and he files on January 1st. Well, it's already past 90 days from when I filed my lis pendens. So that cause of action won't stand. And I think now, understand, that's just one of the two types of causes of action. That's the voidable preference. So I think that's going to go away. I think if, now understand, this is one of the bankruptcy judges. Each of these cases is one of the bankruptcy judges. In the technical world of what constitutes precedent for all courts, an individual trial judge's decision is not necessarily binding on any of the other judges. But interestingly enough, when this second judge, which is a different judge, issued the opinion with respect to the fraudulent transfers, that's anytime within 2 years of the date of the transfer, the action can be brought. That judge cited the case that I just talked about, cited the earlier case and said, yes, I think that the date of the transfer was the date of the filing of the lis pendens, not the date when the final judgment was taken. So now you've got two judges who have reached the same conclusion. And now you would say, well, 2 years is different than 90 days. And that's true. 2 years is different than 90 days. 2 years gives them a much greater, I mean, there are fewer, maybe far fewer, bankruptcy actions that are filed outside of 2 years from when you filed your lis pendens. I mean, if using the example I just used, I'd have to, if I filed my lis pendens on January 1st, 2018, and I finished my foreclosure 6 months later or 9 months later and took the property, well, they'd have until the end of 2019 to file the action. That would be long after I took the property, still within 2 years of when the lis pendens was filed. So that's not going to be quite the same. Now it happens that the decision that came out, it was more than 2 years from the date of the filing of the lis pendens till they filed the fraudulent transfer action. So in that case, it worked. But I see another possibility, and this, again, this is my speculating. This is not based upon, like I said before, there's always a risk in talking about new law before it's had a chance to really play out. But to bring an action under fraudulent transfer, the 2-year limit, the debtor has to say he was either insolvent on the date of the transfer or was rendered insolvent by the transfer. That was different when you were talking about this final judgment. You said, well, one day I had this house, I lost it that day, I was rendered insolvent. It's true I wasn't insolvent before that day, but after you took my property, then I was insolvent, so I meet that test. Well, when I filed the lis pendens, I didn't take your property. You still owned it. So the question is, does the value of the property get included in determining whether you were insolvent either on the date of the transfer or you were rendered insolvent by the transfer? I would say, I didn't take anything from you of value when I recorded my lis pendens. You still had whatever equity you claimed to have in the house, you still had that day. That may make it much more difficult for a debtor to prove that he was either insolvent or rendered insolvent by the transfer. So I think both of these will operate as new and potentially very valuable defenses to these claims. Everyone who does what I do, when these cases started to hit, were very concerned about them because you couldn't really protect against it. There was nothing, you just did what you did, and then you waited to see whether a bankruptcy was filed. And I had already, in my earlier talk with you and in my papers, I've said there are some defenses, but they're not easy. To me, these are pretty clean because they tell you this is the date. Look at the date of the lis pendens, not the date when the final judgment was entered. Start to count on that day, and I think it's going to be significant.
So it's like you said, assuming it plays out, we'll see it when it gets tested in court a few times. But in both cases, it's good for investors. One, it starts that clock earlier, and really that clock runs out before you ever get the final judgment, right?
It certainly does with respect to with the voidable preferences, because that's a 90-day look back period. And again, you might if I was representing a municipality, which I don't typically, I might be able to get a final judgment inside of 90 days because it's a different procedure. But on my typical foreclosure, I'm not at final judgment 90 days after I file the lis pendens. My clients would love it if I could do it. But the system wouldn't even permit it because the redemption periods within the case are longer than that. So
got it. And on the second type, it at least moves that timeline up, right? If you say average is 6 months for,
or even up to a year. I mean,
you got to wait 18 months instead of 2 years, right? As well as they don't have as much of a leg to stand on, the debtor, in filing that, because like you said, filing that lis pendens isn't making them insolvent as a final judgment would.
That's what I say. And I think that that's pretty clear because, I mean, when you bring a avoidable a fraudulent conveyance action, you have these boxes you have to check. And one of the boxes says, I got to say, I was either insolvent on that day when the transfer took place or I was made insolvent. If you can't check the box,
right,
you can't meet the test. Now that's going to be a fact-based inquiry, but I think it's another arrow in your quiver in terms of your defending these actions. And I think I couldn't, let's just say I couldn't leave my comments to you go without adding that, since it's all very recent. The second of those two decisions came out on February 20th. So I wanted to make sure that we covered that.
Excellent.
And who knows, maybe tomorrow there'll be another case.
Well, if anything does come up, Bob, we'd love to hear from you. We greatly appreciate the update, and thank you, everybody. I'm sure they.
Oh, I have to say one more thing because I got to give a shout out. Because two of my compatriots got these decisions. One was Gary Zeitz, and the other was Keith Bonchi. And I, as I said when I wrote to you, I said, I want to make sure you know. I mean, these are guys who, they did it. They did a service to the industry by getting these decisions entered.
What was their name one more time?
It's Gary Zeitz and Keith Bonchi. They're obviously two different firms, and they're guys who I've known for a long time, and they're really good at this stuff.
Well, thank you, Keith and Gary.
Yeah, that's all.
Excellent. Well, thanks again, Bob. We appreciate it.
Take care.
You too. Cheers.
Bye-bye.